Hi, I'm Amy Papandreas from Southern Waters Legal. Today I'll be speaking about subpoenas in family law matters. Subpoenas are a very common concept, but often people don't know exactly what they mean. Basically subpoenas are a legal document which compels a party to provide evidence in a matter. That evidence can be by way of producing documents, or it can be to give evidence orally, so giving evidence on the stand. Or it could be to provide evidence and give evidence on the stand. So it can be both. In family law matters, there is an obligation of full and frank disclosure, so the parties to the proceedings are required to provide certain documents under that obligation. If a subpoena is required, it's generally because a party has refused to give documents or because a party is unable to give documents for any reason. For example, if there are issues of confidentiality. So for example, you may issue a subpoena to a bank to provide certain bank statements of a party to proceedings, and that bank can't provide those documents to you without a subpoena because they have confidentiality issues there. In terms of the process of filing a subpoena, a common misconception is that that a subpoena can just be used in any matter. That's not true. Your matter does have to be before the court, so you have to have filed proceedings to be able to issue a subpoena. If your matter is in court, you can file that subpoena. To do that, the document gets filed with the court by your solicitor. Your solicitor will be required to prepare that document and set out exactly what you're required to be provided by way of evidence. That has to be quite specific because if it doesn't meet certain rules and requirements, then the subpoena can be objected to. So if a subpoena is issued, there is an opportunity for the person who receives that subpoena to then issue an objection. Circumstances where it can be objected to vary. Things like if the subpoena is too broad so as to make it a fishing expedition, that would mean that the subpoena could be objected to. If the subpoena is objected to, the parties then have to go to court and satisfy the court as to why that subpoena is relevant. So there are certain requirements that need to be met, which your lawyer will likely guide you through. Once a subpoena is filed, that party who receives the subpoena will receive it by way of service. So if it's a company, for example, it might just be mailed. Then they're required to comply with that subpoena within 28 days. So if that is producing documents and the documents get sent to the court, the documents are then stored by the court and the parties to the proceedings have the opportunity to have a look at those documents. Depending on what they are, if they're sensitive records such as medical records or documents in relation to children, you may not be allowed to photocopy those documents. So you have to go to the court physically and inspect those documents in person to be able to know what the contents are. Other circumstances, if they're just financial documents, for example, will allow you to actually photocopy the documents and take them away. So that's basically what a subpoena is and what the process is. I'll do a part 2 of this video which sets out the costs of a subpoena and also the consequences of non-compliance with the subpoena, because it is a legal document, it is quite serious. So if you'd like to tune into part 2, it'll be coming soon.